Whoa, 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 whoa.
I did nothing. Whoa. I did nothing.
Right here.
Already we got chaos in the courtroom. Notice how the defendant's first instinct isn't calm compliance, he's denial and deflection. That's never a good look when a judge is watching your every move.
Right here.
I did nothing. What did I do?
This is a judge flexing authority. In court, you don't turn your back, you don't walk away, and you definitely don't test. A judge's patience, respect for procedure is non-negotiable here.
I left 2 notes. One for the
face me. Face me. And don't ever do that again.
I left a piece of paper.
The defendant and the victim have been dating for 2 years. They were together on the date in question in the living room having an argument because the defendant accused the victim of cheating.
You will state your name,
of July 20.
take him back. Take him back,
7 months
because take him back, he'll follow the rules or not. Have a good day.
He told her to get on her hands and knees.
3 separate strangulation attempts. Let that sink in. If true, this isn't just domestic violence, it's repeated attempts at control and domination. Quick question for you: should repeated strangulation automatically trigger a higher level felony, maybe even attempted murder charges?
Witness is absolutely unhinged. A defendant who thinks courtroom rules don't apply to him, facing a judge who's about to deliver the reality check of a lifetime. But that's just the warm-up act, because the main case involves accusations so disturbing, so calculated and brutal, that even seasoned court watchers are left speechless. We're talking about a domestic violence case where the prosecution claims 3 separate strangulation attacks, psychological torture, and a victim who literally blacked out from the violence. The defendant's family flew in from Saudi Arabia thinking they could post bail and walk away, but wait until you hear what the judge has to say about that. This is the kind of case that separates the real judges from the pushovers, and trust me, this judge is not playing games. Buckle up, because this courtroom is about to explode, and the fallout is going to be absolutely devastating. Let's dive into this train wreck.
Court calls the case, People versus Amen. Is it Hendrick? I understood.
Yes, one.
Go ahead, counsel.
Roy Brown, Deputy Chief Public Defender, being written on behalf of Mr. Amit Ehrenreich. Please state your name for the record.
To ensure justice is made, I will make 5 brief statements and then state my name.
No,
Dana
you will
from the
state
forensic
your
center
name. You
had
will
first
state your
elected
name.
of July 20.
Take him back. Take him back.
7 months
because take him back. He'll follow the rules or not. Have a good day. We may call you back. We may not. Okay. Court calls the case of the People versus Thomas Chang.
Ready, Your Honor. Your Honor, Joe Simon on behalf of Mr. Chang, making his way to the podium. State your name, Thomas.
Thomas Chang.
Thank you.
Your Honor, first things first, the court has my substitution.
That was a question.
Yes.
I do. Yes.
Thank you, Your Honor. And secondly, the request that I'm going to make is contingent on we want to address bond. That's okay?
Sure.
Your Honor, I told Ms. Grosso I'm requesting only a 10%.
Here's the money talk. The defense is trying to get a 10% bond privilege, meaning instead of putting up the full $200,000, the family would only need $20,000. But remember, this isn't about saving money. It's about whether the defendant is too dangerous to walk free.
Privilege. I'm not going to request a bond reduction at this time. My client's 22 years of age, has no prior criminal history. His bond is currently set as $200,000 cash or surety. I understand I wasn't at the arraignment, but the safety of the victim was an express concern by the people, as well as his possible risk of flight. I can tell Your Honor that my client is a United States citizen. There's some information that his family resides in Saudi Arabia, and that is his permanent address. Well, that is true, and it's also not true at the same time. But he's a United States citizen who has a residence here. That is his full-time residence. Your Honor, I'm only asking for a 10% privilege because the bond could have been posted. The problem with the surety bond, as the court knows, is that the family or others who post it lose that money permanently. And if it were to be a 10% privilege, the family, assuming someone complies with their conditions, will get it back, less 10% for administration. And that is our request. Now, my client's family is here. They came from Saudi Arabia. His parents are here today in the front row, as well as his uncle who lives locally. The complainant and my client do not live together. They do not attend the same university. As I understand, she's a student at Eastern Michigan University. My client's a University of Michigan student. They do not reside together. They have no reason to have contact. And my client would abide by that. So in other words, Your Honor, my request isn't yet this time to try to lower the bond, but simply to the court allow to a 10% privilege. Again, the surety.
But the surety, I mean, if we're really, just to be blunt about it, if we're really talking dollar amount, I understand what you're indicating to the court. But if it's a 10%, who's pledging the additional amount?
Well, there wouldn't be an additional if it's 10%. Are you asking
210%? Somebody is not pledging it, but somebody's going to promise to pay the 200,000.
Oh yeah, that'd be my client's parents. I'm sorry, I misunderstood your court's question. And you're right, Your Honor. There's just two differences on a surety. Surety is the number one difference is the court would be holding $200,000 for the pendency of the case. At the end of the case, it would be returning $200,000, but the person who paid the surety would be out $20,000 permanently. In this case, my client's parents would post a $20,000 if the court permitted a 10% privilege, and they would be responsible.
I mean, I understand the argument, Mr. Simon, but I mean, again, to the extent a dollar figure to secure the defendant's presence is necessary, it almost seems to me that one might get to a 2 million, 10%.
Oh, Your Honor, my client has ties here. He's retained client counsel.
I'm just saying, I'm just talking in terms of the argument
Esoterically?
regarding the amount.
Oh,
That's all I'm saying. If to the extent that the $200,000 is the amount that needs to be secured.
yeah. And frankly, I think that's a very high bond, but I don't think it would ever be higher. And here's why. Here's why. My client's guidelines on his worst scoring, if we go best to worst, are a straddle cell. He can be secured here by turning a passport over, but his also to indicate his mother is going to stay here during the pendency of the case, and his father's trying to relocate his job back to an office here in the state of Michigan. I mean, they're invested in terms of his flight risk. There are ways to ensure he won't be a flight risk. There are also other ways to ensure safety that he's willing to abide by any condition that I've seen the court impose before in cases like this.
Response.
Your Honor, the reason that we asked for 250,000 in this case was because the defendant and the victim have been dating for 2 years. They were together on the date in question in the living room having an argument because the defendant accused the victim of cheating. He got on top of her, held her down with both of his hands, releasing his left hand, grabbing her by the neck, strangling her, causing her to struggle to breathe to the extent that she felt dizzy. He was able to speak, but the defendant cut her off and said, "It's your fault." He then got off of her. They separated for a moment, but he asked her to go to the bathroom to smoke some weed. She agreed, went into the bathroom, strangled her.
This is chilling. Each attack escalated first dizziness, then unconsciousness. That pattern shows intent control, and increasing danger. Prosecutors live for patterns like this because they tell a story of deliberate violence, not just a one-time mistake.
He cornered her in the bathroom, yelled at her to stop acting like that, and strangled her to the point where she couldn't breathe. She tried to push him off, went into the bedroom to get her belongings. And then at that point, she saw the defendant had her phone and was going through her phone, and she tried to get it back. He made her promise that she loved him and wouldn't call her cousin or 911. At that point, he pushed her onto the bed and went into the bathroom with her phone. She followed, trying to get her phone back because she's obviously terrified in this situation. He told her to get on her hands and knees and beg for forgiveness. When she refused and stood up and tried to leave, he strangled her again, a third time, from behind, pulling her backwards. He started dragging her from the bathroom to the bedroom and threw her onto the bed. She couldn't breathe. She blacked out. She couldn't speak.
3 separate strangulation attacks? Making the victim beg on her hands and knees? This isn't domestic violence. This is psychological torture combined with attempted murder. The prosecutor is painting a picture of a predator who knew exactly what he was doing, who escalated the violence each time the victim tried to resist or escape. And the fact that he took her phone, made her promise not to call 911, then continued the assault? That shows premeditation and control that should terrify everyone in that courtroom. This defendant's family better start realizing that their son isn't the victim here. He's the monster. The prosecution just dropped a nuclear bomb, and there's no walking away from evidence this damning.
He tried to get her phone back because he still had it at this time. And at that point, he again reiterated that she needed to promise him that she loved him and that she wouldn't call him. Continued to push her down, to pin her down, and it was only after an extended period of time and she threw a water bottle at him that she was able to get her phone back and call. But it went on for an extended period, including 3 separate instances of strangulation, one causing her to feel dizzy, one to the point where she actually blacked out. This was a prolonged, continued period of violence, and we have significant concerns for the victim's safety.
Your Honor, can I respond? I agree that a lot of those facts are in the police report, but I also have to supplement. First of all, if those allegations are made, that doesn't mean they're true. They're represented as that is what happened in this case, and we have absolutely defenses to those things. I will say this because I don't think it's proper to litigate a case at a bond motion, but I can say this, that I agree that
I'll
after.
tell you what, I'm going to need a written motion. If you can get it to me today, I'll hear this afternoon, but I can't stop the docket to go through this in this entirety this morning. I will be more than happy to set you today at 3:00 to listen to this in its entirety.
Your Honor, may we approach? And I'll be happy to do what the court asks, but may we approach?
Yes.
Thanks.
Any additional information?
Nothing further, Your
All right. The court, in listening to the argument on the case and reviewing the file, because I was also trying to get as much information as I could from the original arraignment and the like, which I had not reviewed or looked at or in any way processed. But in looking at that, the court would not believe that a 10% privilege on this particular bond, given the circumstances of this case at this time, would be appropriate, or find that the magistrate in any way abused their discretion in doing so. So the motion for that modification is denied.
Thank you, Your Honor. I do want to know if the court could possibly give me a copy of the pretrial release order as it stands, because I don't even have that. If I can get that.
Release?
Or that, sorry, the boss.
Yeah, it's generally it's a domestic violence conditional release.
Okay,
but that's fine. You need an actual copy of the.
If I could.
We can take care of that.
Thank you very much. And
what
then,
date would you like it set for? The 13th?
I understand there's a docket going on the 13th.
Why?
Boom request denied. The judge isn't budging again. Honestly, can you blame them? After hearing those details, leniency would have been a PR disaster. What do you think? Did the judge make the right hire? Should the family's presence and money have carried more weight?
I understand there's a docket going on the 13th, Your Honor.
There is.
That would be
it was
great.
supposed to be limited for me, but it's apparently not doing that now because of Simon. So I will set probable cause in this matter for August 13th, 2024, 9 a.m. or as your invite indicates.
So here's what just went down in this absolute courtroom circus. The judge denied the 10% bond privilege, meaning this defendant's family is looking at the full $200,000 cash bond. No discounts, no payment plans, no mercy. After hearing those horrific allegations of triple strangulation, psychological torture, and a victim who literally blacked out from the violence, the judge made it crystal clear that this case is too dangerous for any leniency. The defendant went from courtroom outburst to facing the harsh reality that his actions have serious consequences. His family flew in from Saudi Arabia thinking they could solve this with money, but justice doesn't work that way. The probable cause hearing is set for August 13th, where we'll see if the prosecution can prove these devastating allegations. This case has everything: entitled defendant behavior, international family drama, horrific domestic violence accusations, and a judge who refuses to be intimidated. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments about whether you think the judge made the right call, and don't forget to subscribe for more jaw-dropping courtroom breakdowns that'll keep you on the edge of your seat.